All right. Good morning. It's May 15th and a little after 9:30, and this is the Texas Low-Level Radioactive Waste Disposal Compact Commission. If anybody in the room doesn't know that, welcome. The commissioners present this morning include John Salzman to my far right, Judge Dolgener, Mr. Hurley, our counsel Karen Watkins is here. I'm Bob Wilson, of course. Linda Morris. Ms. Sanders is here for, I should say Dr. Jane is here for Dick Saudick, who couldn't make today's meeting, and Peter Bradford, Lee Ing, our contract executive director, Audrey Farrell, our general helper, do-all person. And those are the folks with the commission that are here. I noticed that Mr. Doyle, of course, is not here, and he is not, and a replacement for him has not yet been named. So we're functioning essentially with 5 rather than 6 Texas commissioners, but that's just the way it's going to be. The way that works is he's still a commissioner. It's just that he's awfully busy with other activities, and so it's just something that he can rarely make these meetings. Let me see. I think I've introduced most people. Who's here from state representatives that I don't, or state elected officials that I don't know? Is anybody want to introduce themselves? Betsy used to be, but I don't have to pay attention to her anymore. Yes?
Dave Hickman, Governor's Office.
Good to meet you. Thank you for coming. Welcome. Anybody else? Are there any press people here who want to be recognized? Most press people don't want to be recognized, but I always make an effort to signify who they are, identify themselves for all of us to know, and thank them for their work. Judge Dolgener, of course, is an elected official, so he's specially qualified to be here. Okay. And now I'm going to turn it over to Mr. Bradford, because we have Commissioner Bradford, because we have some guests with us today who are visiting, and I'm going to let Peter talk about who they are and why they're here and what they're doing. Peter, go ahead.
Okay, well, I'm going to follow your example to lower the stress in one's life by delegating, but I will say a few words. First, a year or so ago, I was fortunate to be asked to play a small part in a project, State Department funded project through the University of Connecticut involving work with some folks in Russia on issues related to the decommissioning of nuclear power plants. And while certainly I'm the smallest cog in that machine, they have become very interested in the issue of where the waste from the power plants will go after plants are decommissioned. It's an issue that's in a different posture at this time in Russia than it is in the U.S. And their interest has led them all the way from St. Petersburg to Austin to this meeting, and they'll go on tomorrow to the site in Andrews. But it makes more sense, I think, for them to describe for us in a little more detail what the project is about and what their interest is in being here today. So either Oleg Bodrov or Nat Trumbull or both of you, whomever would like to speak.
All we ask is that you come up and address us from the microphone, because we record this and we're actually simulcasting it. And so we'll be glad for you to introduce yourselves, and we want to extend a welcome to you for being here. Thank you for
Nat Trumbull, University of Connecticut. Well, it's a pleasure to be here, and the purpose of our visit is a component of our project called Best Practices of Nuclear Power Plant Decommissioning. And the purpose of the Russians' visit is to collect information and then to, they hope, share this with Russian legislators who are making decisions similar to yours. And one of our goals is to again, collect information and make this available in an online educational course type format. So at some point, if anyone had a minute or two to speak on camera, we'd actually be very grateful for that opportunity. But otherwise, I'd like to ask Oleg to say a word.
First of all, I'd like to say thank you very much, Mr. Chairman, for the chance to be here. We arrived 2 days ago. It was more than 10,000 miles from St. Petersburg, and we're happy to be here because the last 10 years we investigated the best international practice how to provide decommission process of the old nuclear reactors, not only in Russia, but we visited Lithuania, Germany, United States, Yankee Mountain, Main Yankee. And we interested very much not only how to provide decommission process, but what is the best practice for the radioactive waste and spent fuel roads management. And we interested to be here to ask some interview and to get information for the education the students in Russia and the United States. Thank you for the chance to be here.
Well, thank you, and as I said, welcome. We're glad you're here, and I'm sure anybody on the commission and the agency representatives who are also here would be very willing to spend a little time with you and answer any questions that you have. And I'm volunteering Mr. McGuire back there and Ray Fleming to do this. If you want to know who they are, I'll point them out specifically. Mr. McGuire's with TCEQ, which is generally the agency in Texas that regulates disposal of low-level radioactive waste. Mr. Fleming is with Department of State Health Services, which regulates our licensees. And, of course, the power plants themselves are regulated by the Nuclear Regulatory Commission. And, I mean, as you know, Mr. Bradford used to serve on that commission, but he no longer does. But anyway, welcome, and we'll provide you with any information we can. Thank you for being here.
Thank you.
All right. All right. The next item on the agenda, as usual, Mr. Bradford, or is that
Yes.
are we done?
Thank
Okay.
you very much.
Sure. We have a section on our agenda. We allow public comment from the people who are attending on anything that they care to address us on, subject to limitations from me of time and sometimes relevance. So is there anybody in the public who wishes to address anything? Yes. Come up, Marvin. And I'll say this also, that each member here who wants to talk about an individual agenda item when it comes up is welcome to ask to be recognized to speak on that agenda item in accordance with our normal practices. Marvin.
How you doing? Marvin Smith with Thermo Fisher Scientific, 57-year manufacturer of low-level sealed source devices out of Houston, Texas. I had the pleasure to speak to a few commissioners a few weeks ago in Oak Ridge, Tennessee, about how we recover and recycle out of sources. And what I had explained to the commissioners before, which is really good news for us in our recycling efforts, before I explained to John that we had, we have break points in manufacturing, 10, 20, 50, 100, 200, 500,000 millicuries, and that we were discussing holding material for decay to allow those to be recyclable. And since I went back to my office, I found out that our software engineers within our custom software developed applications within those mid-range groups. So such as when we developed a 50 millicurie source, which had a plus 20% tolerance on it, so we could use 50 to 60 millicuries. And then we manufactured at 100. Well, now what we've done is we created applications for 60 millicurie source, which sucks up 60 plus 20% to 72 millicuries. And we created a 75 millicurie application, which then goes from 75 to 90 millicuries. So now all the ranges that we have, or all the decayed sources that we're bringing in for recovery and recycling, now we've got applications for most all products. So that's more than, it's probably doubled our recycling efforts in the last 2 weeks. And just in a nutshell, we're hoping to become, as a recycler, the last beneficial user status as a licensed activity. And that's about it.
All right. Thank you. Are there any questions of any of the commissioners? All right, thank you. I'm sure that our technical and rules committee will take all this information and add it to the stuff that we've been collecting already. Thank you, Mark. Okay. Is there anyone else who cares to address us on any issue of interest? All right, if not, the next item on the agenda, item 5, is a discussion of our rules revisions. And on this one, you just heard that we did have a session in Tennessee. I was not in attendance at that, even though I'm on the committee. Mr. Salzman was in attendance, and Ms. Morris and Commissioner Saudick and Lee Ying and a whole bunch of other people came. And I'm going to ask Ms. Morris to give a report then about the Rules Committee and what its activities have been doing, because that meeting was an essential part of the committee's actions. Ms. Morris.
Well, the Rules Committee is tasked with a review of all the rules regarding the radioactive waste. So we're looking at 31 TAC 675. So we really felt like from the beginning we need to have more information to be able to do these review and revisions appropriately. So we quickly determined that the committee is Chairman Wilson, Chairman Saudick, and myself. As Chairman Wilson said, he was not able to attend the meeting in Tennessee last month, but we were represented by Chairman Salzman. But anyway, so we quickly determined the reason we needed to have a meeting is that we really lacked information from manufacturers, brokers, and processors on exactly how business is done and how everything is handled. So we did host a meeting in Oak Ridge, Tennessee in April, and we heard from these different groups. We also did tours. We did tours of Permafix, DSSI, Bear Creek, which is Energy Solutions, Bionomics, and Tosco. And personally, I found this very rewarding, have a much better understanding of how these processes are carried out. And so what we did last week, the Rules Committee met again for 2 days here in Austin at the office of our counsel, the Attorney General's office, ably helped by Karen Watkins and Jim Krausen. And we sat down for 2 days and essentially tried to incorporate everything that we've learned at our meeting in Tennessee. And again, thank you to all of you who participated in that meeting. It was very, very helpful and enlightening to us. Anyway, so we sat down last week and spent this time looking at all aspects of the rule, also the comments that were made and other suggestions that have been sent to us to try to see what we need to do. So we actually came up with a number of concrete suggestions that Ms. Watkins is in the process of drafting our comments into a draft rule, and we expect that to be available to us, to the Rules Committee, in early June. So the plan after that then is once that we've looked over that and kind of think this is the right direction we want to go in, we will put those out for comments sometime around July. Now, we won't be voting anything. The commission will not be voting on anything this summer, I don't think. There may be some discussions and things among the commissioners to kind of there'll be definitely at the July meeting, there'll be another update from the Rules Committee to let everyone know where we are right now on this process. But anyway, so that's kind of the time frame we're looking at. But I think some of the examples of things we looked at included fees. We kind of looked whether we need to charge fees for petitions. Also, if rules already exist, TCEQ rules, for example, regarding commingling, do we really need to have a comment in our rules? And I think we said no, we don't. So, and also we touched on the issue of importation of radioactive waste for management. Now, we didn't make a determination on exactly what direction we're going to go on that, but Chairman Wilson is going to appoint another committee, and he'll address this in just a few minutes in his report. So that is something that we did discuss, but did not come to a conclusion on that. So that's where we are right now. We, like I said, hope to have something out to you guys for comment in July. And it's been such a rewarding process in that we've had so much participation from the generators, from the brokers, the processors, and the manufacturers, and we really appreciate all that, so thank you. Anyway, so I don't know if we want to have any questions right now or just hold on to
Well, if
that.
there are commission questions, certainly we can entertain them. John, you were there, so you know about everything. So anything you want to add?
I too found the meeting to be very helpful, both the question and answer session that we had as well as the tours. I think in terms of the rule process, the only thing I would add is one of the concerns I have with the way the rules are written right now, particularly regarding importation of waste, has to do with speculative applications. I think we have received over the course of the last 2 years some applications that were perhaps speculative in nature, and that gives me some concern. Obviously there's a limited amount of capacity and curies that are available, and it gives me some concern that we would tie up some portion of that capacity, if you will, with an application or if we approved it, that might not ever be used. So it's one of the issues that I've talked about in the rules with regard to how we might change things or concerns. But I guess I say this to all those out there who might send in an application that I personally have a concern with applications that are speculative in nature. And I understand business practice may be that you may not know exactly how much waste you're going to dispose of, but I would ask the Rules Committee to give some consideration to that issue as they come up with a draft. So, thank you.
Any other comments or questions from any of the
Well,
other
I might
commissioners?
add that we are looking at ways to try to make this process more user-friendly, including like changing the dates for certain things. I don't know if Ms. Ng wants to mention that. And also allowing the chairman on some very specific issues, allowing the chairman to approve them without having the whole commission approve things. So that's some very limited things, but it'll certainly help out instead of having to wait for a regular meeting to come around. For certain prescribed instances, we can allow the chairman to sign off on some things. So that'll be helpful, I think, to some people. Ms. Ng, do you have any other comments you want to add?
The only thing I'll add is we're about to sit down, and by where I mean Karen Watkins and I are about to sit down and try and take a really close look at the process that we use today for taking in import applications. In particular, that right now they're deemed received the first of the month. We have a 25-day comment period. They go through the Secretary of State, et cetera. And we know that can be somewhat cumbersome. And we are looking to change that and get out big calendars and colored markers on a big board and start using nuts and bolts techniques to try and look at a different process. And so what I invite anybody who cares about this process to do is to please call, send written comments that we would be happy to look at and use. Meet with us. Now is a very good time to reach out if there are things about the process that you would like to see changed and things that could help you that we might not see that we could do. So I just wanted to make that invitation.
Anybody else? All right. Let me just say for most of you here, most of you who are here know this, but what we're doing is now that the site's been going for a couple of years, we're looking at what we have learned about the business practices, and we're trying to build upon that knowledge to see how we can fit the legislative requirements for operational years and their limitations into our original concept for these rules and how it all might work better. And to do that, we absolutely have to know a little bit about the expectations and operations from a business point of view, because otherwise we're going to make a decision on what we do without that information. So to stress what Lee and Linda said, if you care about this at all, you should probably be telling us what you think. And so we inviting you to do that even during this process. But eventually, we'll have some sessions where all the stakeholders will be invited to come in. And I'm not sure yet, because we haven't made a decision, whether it'll be before or after the official publication date. But we want to make sure everybody has as much input into this as possible. We will have a draft available for comment probably before its official publication, so people can start looking at it. So we're not in a hurry, but we're looking at a lot of things, and the interesting thing is we're learning more month by month and meeting by meeting about the way things actually work, and we need to know as much as we can to factor that into our decision making. And so that, if nobody else has any comments, that'll finish that one up. And then the next one that we'll move to, and for those, Judge, go
I
ahead.
reckon we can budget for Brandon and I, or the rest of us who hadn't gone to Tennessee, to make that trip, just so we'll be all on the same.
Judge, if you want to travel to Tennessee and look at these things, I'm sure we can
We
arrange
absolutely
to do that
can.
as a
Absolutely.
commissioner. You two are free to travel on commission business and just, normally turn it in as an expense item. And if you want to make arrangements for that, I'm sure Lee, with her experience, would be glad to set something up for you.
Is it like a 3-day trip?
It was 4, I think, 4 or 5 in this
It was
instance.
4 with the travel, because you have some travel time to get to Knoxville, and so it probably took, and it depends how many tours you want to do and what all you would like to see. Now, this time there wouldn't be a meeting, I don't suppose, so that would take a day off and some of the complexity, so it could probably actually be more like 3. And I would also mention, I know that Commissioner Sadek had some very nice things to say about it too, so anybody who would like to come, we'd be happy to do it again.
I'm thinking like November, after budget and all that stuff,
Okay.
and before legislature starts.
Right. Okay.
I will mention that I have been to Tennessee before, so I went up there with Chairman Shaw of TCEQ a couple of years ago, so we saw a number of the facilities then and talked. So I thought it would be better to get more commissioners and exposed to what's going on up there this time around. Any other comments? All right. Next, we move to amendments, and for those of you, again, this is primarily for those of you who don't regularly attend. We have a technical review committee, and a couple of our people serve on it, but the spokesman and the head of that is John Salzman, and I really appreciate all the hard work John does. And the reason he was helping us on the Rules Committee is because he fully understands the processing issues from our perspective about what has to go into evaluating the applications, particularly for import agreements. And he does that. And so, John, you're on. The first one is, I guess I should announce the application for, its style is an amendment to an agreement for Duke Energy.
That's correct, Mr. Chairman. The technical committee reviewed an application or an amendment from Duke Energy Brunswick Nuclear Power Plant that was dated February 24, 2014. And in their amendment request, Duke has asked for an additional 9.83 millicuries of carbon-14 to be added to their import agreement. And in addition, they've requested that the expiration date of the agreement be extended to coincide with the end of the operational year, which would be August 31, 2014. I would note that the TCEQ issued a letter dated March 5, 2014, which approved the waste for disposal at the WCS facility. So the technical committee recommends approval of this amendment request, and I'd be happy to answer any questions.
Are there any commission questions for Mr. Salzman? I don't see any. And why don't we go to, are you ready for a motion, John?
I make a motion that we approve the amendment request from Duke Energy dated February 24, 2014, to add 9.83 millicuries of carbon-14 to the agreement and to extend the expiration date to August 31, 2014.
Okay, is there a second to the motion?
Second.
Okay, the motion's been made and seconded. Is there any commission discussion about this particular application? I don't see any. Does anybody in the public care to comment or have any questions or observations or would like to speak to it? Okay. If there's no comments or discussion or other thing, then I think we can call for the question. And we have a motion and a second. So all those in favor of the application, please signify by saying aye.
Aye.
Any nays? Any abstentions? Motion passes. Next one is it Nextera or NextEra?
Next.
Okay. And John, you want to lay this one out also for us? Thank you.
Yes, the technical committee reviewed an application from an amendment from NextEra Energy Point Beach that was dated March 14, 2014, and that would be 1-0051-01, I believe. And in this amendment request, NextEra has asked that the total radioactivity, pardon me, they want to decrease, which I have to say, I think this may be the first amendment request that we've received where somebody actually asked to decrease the total radioactivity, and so I appreciate their honesty. They want to decrease it from 766 curies to 500 curies. In addition, they want to make a change in the technetium-99 from 0 to less than MDA. In the I-129, they want to change the originally submitted information from less than MDA to 5 times 10 to the 7th nanocuries. And they want to change the depleted uranium from 0 to not applicable. I would add that the applicant has not requested any other changes to the volume, waste classification, or waste stability of the materials that would be sent. And April 4, 2014, TCEQ issued a letter stating that the waste was acceptable for disposal at the waste site. The technical committee recommends approval.
Is there any change in the operational year date?
No.
Okay. Commissioners have heard the report of Mr. Sullivan for our technical committee. Are there any questions of him? I hear no questions, so I'm ready for a motion, John.
I make a motion that we approve the amendment request from NextEra Energy dated March 14, 2014 to decrease the total radioactivity to 500 curies, to change the technetium-99 from 0 to less than MDA, to change the I-129 from less than MDA to 5 times 10 to the 7th nanocuries, and that we change the depleted uranium from 0 to not applicable.
Motion been made and seconded. Is there any discussion or question from the commissioner? Hearing none, does anybody in attendance care to comment or have any observations or want to tell us anything about this? Okay. Then, hearing none of that, I'll call for the question and we'll vote on the motion. All those in favor of the motion that's been seconded, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes. Third one we have then, moving on right along to 6C, is the Tennessee Valley Authority. And again, Mr. Salzman.
The technical committee has reviewed an amendment request from Tennessee Valley Authority that was signed March 28, 2014, and officially received by the Commission April 1, 2014. They initially requested to amend the agreement, which was 2-0031-00. However, the amendment request, in the opinion of the technical committee, appears to be more of an actual application. They've requested a significant increase in the radioactivity from initially 2,000 to, they want to change it to 11,000 cubic feet. In addition, they wanted to add, or they wanted to request an additional 900 curies of total radioactivity and an additional 300 millicuries of C14. I sort of thought about this one long and hard, and after some discussion, it's my opinion that it really should be handled as a new application and not as an amendment request. And I think there's some reasoning for that. It makes it more complicated, I think, for the commission to keep track of things. And if we were to continue down this path, then I think an applicant could submit an application and then just keep amending it forever. I guess I don't know where we would call the end of, well, that's, you need to submit a new application. So I made the decision that we were going to process this as a new application. And I believe the appropriate number for that would be 1-0067-00. I guess it's probably, if it's all right with the chairman, that if there are any representatives from TVA that would like to discuss this, I'd be happy to have them come up and discuss it.
Good morning.
Good morning, it's Brian Wood from TVA.
And Mr. Salzman is acting right now for us, so he's
So
effective
I guess I'd invite you to provide your side of the story, if you will, and
Sure.
and I think it would also be very helpful that in our choice to process it as a new application, based on that, are there any changes or anything different that you would request in our review?
The reason why we decided to amend the application versus submitting a brand new application is because we ran out of cubic feet, and we still had curies left on that amendment. So we ran out of cubic feet. We had curies left, and we have a brand new campaign starting for our phase separator clean out. So instead of stopping it and asking for those curies to be moved from one application to the other, we just figured it would be we would just ask for more cubic feet and more curies to go along with that. So that's the reason why we did that.
All right. If we process this as a new application, by my review, you'd be requesting 9,000 cubic feet and 900 curies, 300 millicuries of C14, and by the math, no curies of technetium-99 or I-129. So would I be correct?
That would be correct.
So you, for the additional shipments, you don't believe you need any?
We haven't seen anything in the phase separators for that right now.
Okay. All right. Any other concerns with how we processed it?
You can join me.
Rod, you're welcome to speak.
I just thought I'd give you some perspective from WCS as well. The amendment process is interesting. As Brian said, he had some additional curies that were somewhat left over on the previous application. And instead of having a new application and trying to move those around, it also, it's hard when you ask for 2,000 feet to hit exactly 2,000 feet. So since he didn't ask for additional time, adding those feet and whatnot is probably easier through an amendment process just for tracking. Which amendment do you take it, or which application do you take it off of, and things like that, just from a facility perspective. So we had no issues with it being amendment. I think the same comment period and rules were in effect basically through whether that was an amendment or an application. So At the end of the day, obviously, it's your decision, but I think, this was something that TBA did very conservatively, trying not to do speculative licensing and things like that. I will point out that, we as the facility don't mind particularly the speculative licensing, because sometimes that helps the shipments go a little faster. There isn't a time delay as they wait for the application to come through. If they can do that in advance, even if that is maybe a little bit speculative, I think that can probably get trued up as they go through a shipping campaign and realize how many liners they may actually generate and things like that. You've already seen an example of that where they decrease some of the activity that they don't think they'll need at this point. So I think there's ways to modify and adjust some of that as you consider the rules in a longer term perspective outside of just this application.
Thank you. I would note, as Rod pointed out, the amendment was actually received and noticed as of April 1, 2014, so it received more than the 25-day comment period. It went through exactly the same process as it would if it had been received as a new application, so there was no change there. Do any of the other commissioners have any questions?
The only thing I will do is make an observation to everyone that obviously this is something that we are taking into consideration in our Rules Committee as we are looking at our rules. And this is one of the things that I've been harping on for a year about until we know about the practices in the industry. It's difficult for us to adjust, and until those in the industry know our process about how we calculate and account for things, it's difficult for them to know what we are going through in our perspective, which is the reason I hope everybody participates in our comments as we go through the rulemaking process. In this instance, given that it could be processed as a new application or as an amendment, it seems not to make a bit of difference whether we call it an amendment or just give it a new application number. It's just a question of numbering and designation from my perspective, unless Mr. Salzman sees something differently.
Having reviewed many of these applications and the amendments thereof, I do have a small concern, and that is if we approve it as a new application, if in fact there are any, once you do the final waste analysis and ship that material, if it turns out there were any Tech 99 or I-129, if we process it as a new application, you'll have 0 in there, so that could create a problem. So I guess going on the record, I do have, I think in the rules, we do need to give some consideration to when we're going to terminate agreements in that process, and I think the Rules Committee is looking at that. But with that said, I'm comfortable with approving this as an amendment this time, but I do wish the Rules Committee to address that issue for the future.
Yeah, I understand that now that you've explained it, I kind of understand better now that you've kind of begun a process and stuff, and it's kind of hard to terminate this one and begin another one. So I kind of understand that. It's very helpful, so thank you both for those comments. I guess John and I look at things in terms of curies and volumes and stuff, and so it seemed like an appreciable increase. It is an appreciable increase, the number of curies. So when he and I were discussing it, it did seem reasonable to make it a new application. But I think you provided some justification for, and it sounds like you did consider whether you should make it a new application or an amendment. It did sound like that. So I'll go along with what John just suggested, that we leave it as an amendment.
Okay, if we leave it as an amendment, that reduces the risk to you.
That's correct.
And so that's something that you can appreciate, although the question that we ask ourselves on an amendment, if there's a significant increase in curies, volume, change in weight class, a few other things, when is it that we consider that an amendment versus basically a new application? Because to the extent the comment period and publication is different, we need to make sure that everybody is on board with what the requests are. This was a significant increase, and so we processed it as if it were a new application but we can still call it an amendment in this instance to give you the benefit of the radionuclides that John talked about. And so, ready for a motion, John?
All right, thank you. You're welcome. And I would add that upon the review, the technical committee did recommend approval of it, whether it be an amendment or a new request. So I make a motion that we approve the amendment request submitted by Tennessee Valley Authority. That would be, I always get this numbering wrong on the amendments. I believe that would be, we need to amend 2-0031-00. And in that amendment, that we would increase the volume by 9,000 cubic feet. We would increase the curies by 900 curies, and we increase the carbon-14 allocation by 300 millicuries. And in addition, that we would extend the expiration date of the agreement to hold on a minute. I believe it's September 30, 2014. So I apologize for the length of my motion.
Is it September 30th or August?
September,
31st?
it's, actually, they've requested to increase, well, it's got to be a typo. They want to change the expiration date to September 30, 2015, I believe. Is that correct? I would note they do have a typo in their amendment request, but it would be September 30, 2015.
Help us.
It's 2014. It's 2014. It's 2014, not 2015.
It is 2014?
It's 2014, yeah. We're well underway with it. We have already Hicks on the pad at WCS. I have Hicks already removed from the phase separator, so we are well underway. We're ready to start shipping.
Okay, my apology then. It would be September 30, 2014.
All right. Glad we got that clarified. So you made the motion?
That's my motion.
Is there a second?
Second?
Motion been made and seconded. Any other commission discussion? Questions? Comments? Anybody in the audience who cares to comment on this particular amendment request, as it turns out that it is in fact? Seeing no one who wishes to make additional comments, thank you for answering our questions. And I'll call for a vote on the motion. All those in favor of the motion, please signify by saying aye.
Aye.
Any opposed? No opposition, any abstentions? Okay, the motion passes. That's the third item under item 6, request for amendment, and we'll move to item 7. We'll keep going. Possible action on each of the following applications, proposed agreements. These are new applications for new agreements for importation of low-level radioactive waste. 7A is Tllrwdcc. John.
The commission has reviewed an application from Tllrwdcc that was signed March 4, 2014, and officially received by the commission March 1, 2014, and that was number 1-0061-00. And at this point, I'm gonna ask Ms. Watkins to discuss the issue of whether Tllrwdcc was a new entity or the same entity, and Ms. Watkins.
Let me set the stage for this. We got a comment letter from WCS in response. So that's the reason Ms. Watkins is going to tell us now her investigations. Go ahead.
Well, we became aware that the Tllrwdcc facility was acquired by Energy Solutions and renamed. And so the question was then presented, how do we consider an application from an entity that may or may not still exist? So we did some investigation to determine whether or not the entity that made the application continues to exist. And that involves some communications between me and the General Counsel for Energy Solutions. And we have gotten documentation that the entity continues to exist It simply has a new name, and I'm looking at restated articles of organization for the entity right now that gives evidence to that. So we have concluded that because the same entity that made the application continues to exist but simply is renamed, we can proceed with whatever action the commission desires to take on this application for a new agreement.
Thank you. Okay, John, keep going.
Thank you, Karen, and that's why I asked you to do that instead of me. The Tllrwdcc is a licensed waste processor requesting authorization to dispose of non-party low-level waste in accordance with the Act. They are requesting to dispose of Class A, Class B, and Class C stable solid metal oxides, spinels, carbonates, and aluminates, which are collectively referred to as reformed residue. I would note that the TCEQ issued a letter March 5, 2014, authorizing the facility operator to accept the waste. They are requesting authorization to dispose of 1,950 cubic feet, 12,034 total curies, 13,886 millicuries of C14, 361,491 microcuries of technetium-99, and 60,634,286 nanocuries of I-129. As we do with all applications, the Commission is tracking those volumes and curies to ensure that we stay below the 275,000 curie limit for the year. The waste will be coming from the state of Tennessee, which is part of the Southeast Compact and does not require export authorization. The entity has no unresolved issues with this commission or with any other regulatory entity associated with radioactive material. And I would note that the applicant, to our knowledge, has no other waste disposal facility that they have access to for the material. And they have requested an application or an amendment, I apologize, an agreement that would be from April 27, 2014 through August 31, 2015. So the end of what would be referred to as the third operational year. And the technical committee has reviewed this, and we believe it's acceptable for an agreement. I'd be happy to answer any questions.
Any questions, Mr. Hurley?
John, just so it's clear, in their application, in response to item number 6, they checked yes as to unresolved violations, but in your report it states that was a mistake. They do not have any unresolved.
That is correct. They, in written correspondence, I inquired through Ms. Ng about that issue, and they in fact indicated it was a typographical error, and they checked the wrong box on the application, and we have a written information from them that in fact it was a typographical error.
Thank you.
And if I may add to that, that's happened before. One of the things we'll fix in the form when we go through the rulemaking is make it clear which box goes with yes and which box goes with no.
Butterfly ballot.
Any other questions or comments from the commission? I guess we're ready for a motion, John.
I make a motion that we approve the agreement with Tllrwdcc 1-0061-00, signed March 4, 2014, and received March 1, 2014. The waste will come from Tennessee. The waste description is solid metal oxides, spinels, carbonates, and aluminates, collectively referred to as reformed residue. The waste classification is Class A, Class B, and Class C. Waste form is stable. The volume would be 1,950 cubic feet. The curies are 12,034. 13,886 millicuries of C14, 361,491 microcuries of technetium-99, and 60,634,286 nanocuries of I-129, and this agreement would expire on August 31, 2015.
That's your motion.
That's my motion.
Is there a second?
Second.
Motion been made and seconded. Is there any discussion among the commissioners? Questions, comments? Rod, WCS made a comment about this. Do you want to state anything or say anything to us as we go forward on the motion?
Rod Balzer, WCS. Since you called me out, I guess I should. We did submit a letter just notifying the commission that we did not have a valid contract at this point in time. I know there's been some concern about speculative import agreements and things. Just wanted you to be cognizant of that. As I mentioned earlier, we're happy to have speculative agreements on the potential waste arrives. Just wanted you to know the odds of that.
Thanks. And as you know, we don't know anything about your contracts.
Absolutely.
All right. Any other questions or comments? Thank you, Rod. From anybody? All right. Hearing no other questions or comments and having none from the commission, I guess I'm ready I'll call a question and ask for a vote. All those in favor of the motion that's been made to approve the Tllrwdcc application, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes.
Mr. Chairman, if I may clarify, are we going to be, I'm assuming we're going to be drafting the agreement in the name of Irwin Resin Solutions LLC, which is the new name of the entity?
I imagine that we will draft it in the name of whoever our attorneys say it should be drafted in the name of.
Thank you.
And we can recognize, if we have to, that the Tllrwdcc application, there was a name change, and it's now, so we could say originally filed as, or whatever you want to do. Okay.
I would add that that's, Tllrwdcc is what was on the actual entity name for the application that we received, which is why I used Tllrwdcc.
Right.
So.
And we can take that, formerly known as Tllrwdcc or now known as, we can do that. Right. Next, 7B, Thomas Gray and Associates. Mr. Salzman, you're still up working.
The technical committee received and reviewed an application from Thomas Gray and Associates Environmental Management and Controls, hereafter referred to as Thomas Gray. That was received or signed March 11, 2014, and officially received by the Commission April 1, 2014, and that's numbered 1-0063-00. In this case, Thomas Gray is a broker who is a licensed waste processor and collector requesting authorization to dispose of low-level waste in accordance with the Act. I would note that Thomas Gray has not provided generator authorizations for the waste, but they did indicate in their application that they would be providing those prior to any shipment in no more than 3 submittals, which I believe is acceptable to our staff for review. They're requesting authorization to dispose of our import agreement for Class A, Class B, and Class C stable sealed sources. And I would note that TCEQ approved that waste for disposal in a letter dated April 4, 2014. Their request is for 100 cubic feet, 90 total curies, 100 millicuries of C14, 100 microcuries of technetium-99, 100,000 nanocuries of I-129, and 10,000 microcuries of depleted uranium. They have no unresolved issues with the Commission, nor do they have any with any other entity with regulatory authority over radioactive materials. The applicant has requested to be authorized to dispose of waste from the states of California, New York, Virginia, Connecticut, North Carolina, Maryland, New Jersey, New Hampshire, Florida, Pennsylvania, Colorado, Nevada, New Mexico, South Dakota, Illinois, North Dakota, Arizona, Indiana, Minnesota, Ohio, Oklahoma, Louisiana, Kansas, Nebraska, Alabama, and Tennessee. Those represent the Southwestern, Southeast Compact, Atlantic, Appalachian, Central Midwest, Midwest, and the Central Compact. And of those compacts, the Southwestern Compact, the Rocky Mountain Compact, the Central Compact, and I believe the Atlantic Compact, is that correct, Lee, require export authorization?
They all do except the Atlantic Compact.
Okay. In addition, I would note the states of New York, North Carolina, Nebraska, and New Hampshire are unaffiliated, and so they don't require any authorization. The applicant has not provided export authorization documentation, so that would also be needed before any waste could be shipped. The applicant, to my knowledge, has no other home for the waste, at least the Class B and the Class C. In addition, they've requested that this waste be considered under a small quantity generator authorization, and I believe based on the volume and curies that would be appropriate. And I would note that they've requested an import agreement that would be from April 30, 2014 through April 30, 2015. So close to our old disposal year. And I would indicate that the technical committee recommends approval. I'd be happy to answer any questions.
Any questions on this application for Mr. Salzman? Comments? I guess we're ready for a motion, John.
I make a motion that we approve the import agreement 1-0063-00 from Thomas Gray and Associates, signed March 11, 2014, received April 1, 2014. The waste would originate from the states of California, New York, Virginia, Connecticut, North Carolina, Maryland, New Jersey, New Hampshire, Florida, Pennsylvania, Colorado, Nevada, New Mexico, South Dakota, Illinois, North Dakota, Arizona, Indiana, Minnesota, Ohio, Oklahoma, Louisiana, Kansas, Nebraska, Alabama, and Tennessee. The waste description is sealed sources. The waste classification is Class A, Class B, and Class C. The waste form is stable. The volume is 100 cubic feet. The curies are 90, 100 millicuries of C14, 100 microcuries of technetium-99, 100,000 nanocuries of I-129, and 10,000 microcuries of uranium-238. And the agreement would run from a period of April 30, 2014 through April 30, 2015.
Okay. That's the motion. Is there a second?
Second.
All right. Motion been made and seconded. Is there any discussion among commission members? Questions? Comments? Hearing none, does anybody in the audience care to address this particular application? I don't see anybody jumping up to talk to us. So, all right, I'll call for a vote. Call for question and call for a vote on the motion.
If one additional
Go ahead.
issue, I apologize.
That's all right.
I believe in my motion we need to indicate that there would be two stipulations in the agreement, and that is that they're required to provide us any necessary export authorizations as well as signed generator authorizations in no more than 3 submittals prior to any shipments.
Did I jump the gun? You hadn't made the motion yet? Or did you make the motion? You're just adding that to the motion.
I believe I made the motion. I'm having to
All
amend
right.
my motion because I
All right.
forgot to add those stipulations.
That's okay with the second, I assume. Yeah, all right. So that's the motion and the second. Is there any other discussion or any other additions or questions? Anybody in the community here want to address this particular application? I don't see anybody, so I'll Call for a question and ask for a vote. All those in favor of the motion approving the application of Thomas Gray and Associates, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes. Okay, next, Exelon.
The technical committee has reviewed an application from Exelon Generation Company, hereafter referred to as Exelon, was signed March 25, 2014, and received by the Commission April 1, 2014, and that's number 1-0064-00. In this case, Exelon is a generator requesting authorization to dispose of low-level waste in accordance with the Act. Exelon has requested authorization to dispose of Class B and Class C unstable, dewatered, bead and powdered resin, condensate filter sludge, decontamination resins, fuel pool, skimmer, filter sludge, non-fuel reactor components, process filters, reactor water cleanup resins, and reactor water demineralizer resins. And I would note that TCEQ issued a letter dated April 4, 2014, approving authorization for the WCS to receive these materials. And at this point, Miguel, would you like to come up and provide some additional information concerning the application?
Good morning.
Morning. I'm Miguel Azar for representing Exelon Generation. What I requested is if it's possible to add Class A to this current request. And the reason I'm requesting that is at the time of shipment, we typically decay correct some of our storage volumes, and we may cross from Class B down to Class A. So I would prefer that if that was to occur, it would just to keep the process moving, that we would just allow this Class A waste that still requires that same type of shipment configuration to be shipped to WCS. It's not our intention to ship Class A, but if it was to occur, it would just it would slow down our schedule. So it's more of a convenience request than anything else.
You mean it would slow down your schedule if we had to meet to amend the import agreement to add Class A at the time you actually prepared the shipment to send? Is that what you're?
That would be. It's just it's a contingency request more than anything else. If not, I will submit an addendum to this application for the following month. I'm just trying to save myself one more trip.
You're saying that in essence, if that you would request an amendment to add Class A if we don't approve it today?
Correct.
Okay. That's helpful for me. Or are there any other questions?
Well, my question is how we would handle it, because don't we normally specify quantities, A, B, and C, or do we care?
Mr. Chairman, we have not in the past requested the applicants to indicate volume, just total volume, not a breakdown between Class A, Class B, and Class C.
That's the issue that Richard always brings up.
Sir?
That's the issue that I believe Commissioner Sadek always brings up is dividing it among the different classes. So.
Yeah.
And I think that's an issue that perhaps the Rules Review Committee is going to look at that issue.
So there wouldn't be any change that carries?
Slightly, very minimal. It's
but that would be a decrease, correct?
Decrease,
not an increase, correct.
Yeah, that's what I thought. I just wanted to know whether it would be a variance. So the volume would stay the same. The carries might go down to the point where there'd be have an additional Class A, instead of the Class B and C that you're limited to under the original application.
Correct.
Okay.
Any further questions for Miguel?
I just kind of watching out for the public in this deal, that this has been on our agenda as a Class B, Class C. Now we're changing it to Class A, and the public is not aware of that change. And it's not, I mean, he says he can bring it back next month. I would think I'd need to bring it back next month.
Next month, I think, means July.
Or whenever we meet again.
Yeah.
Because it is a substantive change. It's not, but it is. I mean, they could say,
I
you guys
understand.
approved something that wasn't on the agenda. I mean, that I didn't know about. And
I understand,
I
and
totally
you're
know
sensitive
what
to these issues, I understand that,
I'm very
Judge.
sensitive to issues because I have them every Monday, but, because, you know, you just, I don't know, we're trying to follow the law, that's the law, and I don't know, Brandon, what do you think? I mean, it's one of those technical things in the law, but it's there, as far as the Open Records Act.
What he's talking about is the open records posting requirements. If it's not on our agenda to act on it, can we act on it? Even if it's amounts to a practical problem of where we're decreasing the classification, it's still not something that's posted.
And also, we have not given the public an opportunity to comment on the idea of it being A.
Yeah.
Your counsel would be a lot happier, I'm sorry, Miguel, with an application that's properly posted.
I understand. I have my legal folks too.
Another
Okay.
comment that I want
Did they
to
agree
make.
with us, or,
Pardon me?
did they agree with us, or?
That's fine. Yes, I agree with you.
I mean, the lawyers agree.
You know, I have a feeling in the past we probably have had situations where petitioners have requested only B and C, but technically they're going to have some A because of decay and stuff. So, you know, we get into that issue. There probably really was some A, but it wasn't requested. But that's just natural due to the radioactive.
I think we
decay.
have had
Yes, we probably have had this situation.
amendment
You're just being
requests in the
honest.
past to add Class A.
Yeah.
But it does, I mean, even when you have it at the burial site, it's decaying too. So, I mean, even though it comes in as B, it may end up being as A 6 months later.
All I'm doing, is saying that what is put out, that the public has a right to say something, is not here.
Okay.
I don't like changing the Commissioner's Court, because the same thing happened. When we changed something in Commissioner's Court, you know, the clerk can write, well, okay, we said A, but there's nowhere in the public documents, if you went back and looked, you'd say that, because I asked Solomon too, this is Class A. Well, you didn't ask for Class A. It says Class A. And I'm going, and it's a very technical thing, but I think we need to try to do, as the Attorney General says, I think we need to do it.
No problem. We all like to play baseball. What are the rules?
Well, the interesting practical question that occurs to me is what happens if we approve just Class A, Class B and C, and when you ship it, it's Class A, B, and C. Is that in keeping with the import agreement that you would have with us?
I wouldn't ship it. It's very
You wouldn't
simple.
ship it as Class A?
I couldn't.
I think Miguel's indicating if it was Class A, he would not ship it until he received an amendment.
Ah, okay. Oh, that's, you know, when does it, I'm not technical enough to understand when it might cross over from B because of time down to A.
It's all driven by, like you said, it's all driven by time. It depends on which isotope is the driving classifier. So it's kind of hard for me to give you a generic answer to that question. So that's
But when
why-
you ship it, do you identify?
Yes, at the day of the shipment, we have to update our records and say, as of today, this is what it is. That's why you kind of have to reevaluate it the day of the shipment.
Mr. Chairman?
Go ahead,
Is
Brandon.
there the possibility that literally in transit,
No.
it changes its classification? It can't do that quickly?
No, couldn't do that quickly.
And this may be a question for WCS, but has this, as a practical matter, ever happened before, where someone has authorization for B and C and they show up with A?
I'm turning to our technical expert.
Morning. I'm Sherry Furnett. I work in technical services at WCS. The way that it works is some nuclear power plants, like Miguel's, decay the activity that are in the shipment to the day of shipment. Once that's on the shipping papers, that's the waste class of that container. So based on what it is on the day of shipment is what we receive, and that's documented on the shipping documents. So we don't decay it anymore. What they've sent to us is what we receive, and it's that waste class at receipt.
But the physics doesn't stop, so.
No.
Obviously, it does go on.
And I would note that in I believe, WCS's current licensing situation, they do decay the inventory that's received at the facility. And as Peter's pointed out, material continues to decay over time. But there has to be a sort of day of reckoning, if you will, and that's the day they print those shipping papers and the day they sign them. That's what the waste is.
Incorrect. At the time of receipt, it goes into the inventory, and it's no longer a waste class. It's a activity inventory for the entire facility.
So Miguel, if I understand how you do the shipping then, would the classification be based upon a particular shipment or a container in a shipment? How does that work?
Classification's based on the container in the shipment. It's kind
And
of-
so if you have a container and on the day of the shipment you decide, whoops, this isn't B or C, but now is A, what you're telling us, you just wouldn't ship that until you had an amendment if we had an agreement with you for B and C.
Correct.
Okay. Brandon?
That answered my question.
Okay. Any other questions or comments? John?
Thank you all. I appreciate your information. Exelon has requested Class B and Class C unstable materials. The Exelon has no unresolved issues with this commission or with any other entity associated with radioactive materials. I would note that the waste will originate from the states of Illinois, Pennsylvania, New York, and Maryland, which are part of the Central Midwest and Appalachian Compact, and New York is unaffiliated, and none of those compacts require export authorization. They have actually requested import agreement in the amount of 4,255 cubic feet, 6,500 curies of total radioactivity, 4,123 millicuries of C14, 1,879,132 microcuries of technetium-99, and 7,350,000 nanocuries of I-129. And I would note that I'm not aware that they have access to any other disposal facility for the materials, and they have requested an agreement that would run from June 1, 2014 through August 31, 2015. And the technical committee recommends approval of this agreement.
This from the states of Illinois, Pennsylvania.
Right. Did I indicate the states the waste was from?
I thought you did.
You did?
Yes.
Okay.
More coffee. I'm sorry.
And I'd be happy to answer any questions about it.
Are any questions from Mr. Salzman on his report from the commission?
I'll just say, Mr. Chairman, I can vote for this as it is, B and C. If Miguel does B and C, but if there's A, then he needs to come back to the commission.
Right. I think he understands that and
Right,
has
well,
agreed
it's
to
on
it,
record.
but, okay. All right, I appreciate that, Judge. Any other questions or comments from the commission? I guess we're ready for a motion, John.
I make a motion that we approve an import application from Exelon Generation Company, number 1-0064-00, that was signed March 25, 2014. The waste will originate from the states of Illinois, Pennsylvania, New York, and Maryland. The waste description is dewatered, bead, and powdered resin, condensate filter sludge, decontamination resins, fuel pool, skimmer, filter sludge, non-fuel reactor components, process filters, reactor water cleanup resins, and reactor water demineralizer resins. The waste classification is Class B and Class C. The waste form is unstable. The volume is 4,255 cubic feet. The curies are 6,500. 4,123 millicuries of C14, 1,879,132 microcuries of technetium-99, 7,350,000 nanocuries of I-129, and the agreement would run from June 1, 2014 through August 31, 2015.
Is that your motion?
That's my motion.
Is there a second?
Second.
Motion been made and seconded. Is there any other discussion or commission questions pertaining to the application for B and C, not for A? Does anybody in our community here wish to address this particular application or the commission's consideration? Okay, then I'll call for the question. All those in favor of the motion as stated by Mr. Salzman, please indicate by saying aye.
Aye.
Any opposition? Any abstentions? Motion passes. I noticed that the next item on the agenda, 7C, is comments regarding all amendment requests, but I think this is just it pertains to the amendment requests that we've already considered, and so it's not a separate agenda item for us to consider that. Is that correct?
That's correct.
All right. All right. Well, at that point, we've been going an hour and 15 minutes or so. What I'd like to do is take a little morning recess, and then we'll be able, I think, to get through the rest of the meeting. We'll convene about 11, and this is, of course, in honor of Mr. McGuire, who's always proud to say that I always call on him right after the morning break or lunch break. In this case, it's going to be Department of State Health Services. So we'll keep going after we come back about 11 o'clock. We'll take a morning break. Thank you.
As we used to say in West Texas. How are you? Been there, done that. Great.
I understand. Yes, sir. Can I get your stuff? Sorry we missed you. This is for. We ate the Joe's pizza pasta. This is where Mommy Hana was the special of the day, but decided against it. So maybe next time. And then we're still with buddies. Is that what the one Glenn was telling me? He told me there was a steakhouse like down the main street past Broadway on the right. All right, well, I'll try something new next time. I'll be back. Yes, sir. I'm pretty sure Rod's going to send me back as frequently as he can. I'll brush up on my Russians. They're going to be there right around lunchtime. I think they're leaving here at 4 a.m. and driving. So Alicia expects them right around lunchtime. Or in my key.
Containers that it can be done it does get some QA challenges and some testing, particularly typically Class A waste when it arrives at the facility. The other thing they can do is they can open up some of those containers and then do spot checks, but only really on the lower dose rate stuff. What they can do on some of the higher dose rate stuff is they could, they have instrumentation that they can put near the container and get an idea of what's in there. But they would never go back.
For purposes of a permit or anything like that, they don't need to say, be careful when you have on that site.
Now they do keep, they absolutely keep track of it. They know what every container is. They know the radionuclides that are in every container. They can keep track of and decay those. They decay that down so they know
What their net is
at any given point. Absolutely. That's one of the good things about the physics.
Yeah.
It continues decay based on
Right. So it's not unlike that what leads to
it's a big spreadsheet.
well, it's never moving forward. You don't really know.
Well,
You know it.
you know what the limit is. It's just how much you have towards that limit. That's always going down. But then they're getting waste.
both sides are.
It's a math problem.
Right, yes.
Me too.
We'll see, unfortunately.
That was the plan, yes, I'll be here. These guys are there.
Well, that's not what you said, but you're not.
What I said.
Basically, I'm chopped liver. That's exactly what I heard. I think that's what he
That set off my whole set off. Now they put it up at the scope.
This is
You know, that, you're doing a great job. Ask about Ken. Ask about Ken. Ken has given all
Yesterday, yeah. So we were there for a long time. We were there for a long time. But I was going up there actually. Since he's her age. They actually met the guy. So we
Go ahead and step up to the plate.
He's the head guy in the league. Okay, thanks. Appreciate it. I think I need to wait for my group.
What?
I need to wait for my.
Yeah.
Glad you're here, glad you're here. I've done it. Yeah. It's a small community. What? That's a compliment to me.
Hi. Governor's office.
Oh, hi, Ray Conley.
Good to meet you,
Yes,
Ray.
yes.
We may have talked on the phone at some point.
Yeah, maybe. You can give me my card.
No, I'm in.
Thank you very much. We're actually working to wrap up with NRC to make sure they know who their contact is for the state.
Okay.
And we've been working with y'all too. And then because you kind of
Yes.
that role in the past.
Yes. Yeah.
From what I understand, we need to keep going. But, yeah, it's very interesting.
Yeah, I mean, Richard Ratler's the main contact, but no, he didn't come today. I worked directly under him and I backed him up.
Oh,
so.
okay, yeah. He and I talked, I think last week or just before that, and I told him, I told him that we would be getting that final confirmation letter from NBC.
Okay, good.
So if you talk to him, tell him it is in the works.
In the works?
He's just
All right.
got so many plates spinning right now.
All right.
Yeah, we
understand
appreciate
that.
what y'all do, being that first line of contact, and certainly keeping line of communication open with our office. It's always a value. So, are you just kind of explaining today what y'all do?
There's always some confusion about what TCQ does versus TSHS, and we do have a big piece of the puzzle as far as waste disposal. And so they asked me to clarify that. Some of the commissioners have more knowledge on that than others, and so I was just going to make myself available to answer questions.
Yeah, I've had to go through. I went through a few people. So from Nazi Landing, who had done it from the governor before, and TCQ would like to explain where it emerges. It'll be nice to hear it again. It's always good to reinforce that knowledge. Yeah, it's really good. So Richard, you can give me a call too. So far, so good. I'll keep protecting the public good over there.
Yeah, keep working on it. We have some workers who are more troublesome than others.
That's in the office.
We have a lot of radiographers who don't want to carry meters and protect themselves. So.
Really?
Yeah.
So they got to do it. I worked in an environmental lab.
We try to remind people that they have to protect their workers.
You absolutely have to, yeah. Especially with everything going on with SOA and finding like an oil and gas, there works a lot of oil and gas fields.
Well, and that's one of my large area right now is doing naturally occurring radioactive material from oil. And it's in the media, especially with fracking issues. And
Lord help us, nothing turns up in a warehouse somewhere in the middle of a neighborhood.
Well, yeah, that's always a potential problem, especially with radioactive drill pipe, and it could end up places. A lot of times people just are unaware of it.
That's the big concern with the wildcatters out there. Not really knowing. A lot of people don't know.
The big oil companies tend to do a good job, but the wildcatters, they tend to be narrowly focused on profits and getting the job done fast. And I hear anecdotal reports that are disturbing.
Okay.
Just trying to keep up with that as much
Well, please, on behalf of the state, stay on top of that as much as you can. And if anything is, if y'all are hitting any barriers or walls, let us know. The governor and I were talking about this just last week, and he wanted them to make sure that none of that is happening in the state. I think it was Oregon or was it Ohio? They found a lot of socks.
They had North Dakota had a problem with that, and we do try to keep an eye on it, but I hear reports of it's too hard to dispose of in Texas, so we drive across the border to Oklahoma.
We're glad you come anyway.
So I hear horror stories or someone gets stopped at a waste site disposing of some waste. And they said, well, they never stopped us before. We've been dumping it there 30 years. Well, the waste site just got a radiation report, so they just had an alarm system. So we think there's some longer-term problems that are just part of the industry where there's having good progress. So I've been trying to attend meetings and trying to increase awareness of issues. And encourage people, the companies to do
All right, folks.
assessing.
We're about ready to resume our usual 10 minutes after the time we said we would schedule.
What the policy options out there might be.
I'd love to. Yeah.
Great talking to you.
Okay. Good talking to you.
Okay. Lee went down to get a cup of coffee, but she said we could start in her absence, which was generous of her to trust us to do that. Next item on the agenda is, and I'll just give a short introduction to this. A year ago or so, maybe more than that now, I had made a suggestion that we might start calling in people either in addition or in lieu of TCEQ at one of our meetings, and I had a list of 13 different groups that we might come in. Department of State Health Services, Texas Department of State Health Services was high on that list because they're one of actually 3 agencies in Texas that deal with radioactive materials, and the other 2 being TCEQ, of course, and the Railroad Commission. Most people forget about them. And then we have other groups like the Nuclear Regulatory Commission and Conference of Radiation Control Program Directors, and even the Low Level Waste Forum that's been in here for us, and other groups like that. So we decided this session to invite Ray Fleming from the Department of State Health Services to be here. And by way of introduction, I will say that many of you, probably almost all of you, are aware of the Texas Radiation Advisory Board, but you're not. Carlos, it's good to see you. We might not be available. You may not know of its functions or of its relationship to the way this all works. And so one of the things I invited Ray to do, and the trigger for this in part was because I noticed in the Texas Register there was a proposal on a new memorandum of understanding with TCEQ that pointed out the separation between TCEQ and the Department of State Health Services, and I know they also have one with the Railroad Commission. And so I invited Ray in to talk to us about Department of State Health Services' role in looking at people with nuclear radioactive materials licenses, and in connection with a little bit about what we do, and invited him to speak. And I'm going to turn him loose to let him talk. And I did tell him before the meeting that I've seen their report that they intend to file with the Radiation Advisory Board on Friday. There are a number of things that in there that looked interesting, and if he wanted to mention any of those, we'd be glad to hear him. Ray?
I'd be happy to. Thank you, Mr. Chairman and Commission, for inviting me. Always happy to speak. And I don't have a long prepared statement, so feel free to interrupt with comments at your leisure. As far as the jurisdiction, it sounds simple in principle, but it's very complicated, as the memoranda leads to. The Health and Safety Code puts responsibility for the TCEQ for non-oil and gas waste. They're responsible for processing and disposal. The Railroad Commission is responsible for disposal of oil and gas waste, but not processing, except, I'll get into it. And then DSHS gets everything else. And everything else is a lot. I am the radioactive material licensing group manager. I have over 1,600 licenses with 2,700 sites and an additional 500 sites that are under general license acknowledgments. And those are many of the waste generators. We do not have authority over Nuclear Regulatory Commission sites, the nuclear reactors, as has been previously mentioned today. And we also don't have authority over federal government entities or their prime contractors, and we don't have authority on exclusive federal jurisdiction. But we basically get everything else. We have a big hand in the waste processing and disposal in the state because most of our licensees are generating the waste and storing it and processing it and shipping it and even disposing of it. The memorandum of understanding goes into a lot of those things. One example is there's disposal by sanitary sewer. It can be just flushed down the drain as long as it can readily mix with the water and it doesn't exceed a certain monthly concentration limit. It's one of the few areas where you're able to dilute the waste and put it into a public non-radioactive facility. So we do have that. We also have decay and storage. If it has less than a half-life of 120 days, then it can be decayed until it's below background and then disposed of either based on its other hazards or as non-hazardous waste in a municipal site. And those two provisions allow most of our medical users and academic users to dispose of a lot of their waste. In addition, with medical waste, most patients are released after a diagnostic procedure or a therapy procedure. And so that waste goes to the sanitary sewer and goes to the local municipal site and is not treated as radioactive waste. But for the most part, that's short-lived isotopes that have present very low risk to Texans, either the public or the workers. In the industrial setting, it's a bit different. Most of the time, those are sealed sources. We have manufacturers and distributors who distribute those sources, some of them in-state, some out, and also foreign. The foreign sources have to have a U.S. distributor licensed by the NRC or an agreement state. And Texas is an agreement state that has an agreement with the Nuclear Regulatory Commission to have jurisdiction within the state. But we work hand in hand with the NRC on everything we do, and they recently concluded earlier this year every 4-year inspection called an IMPEP, Texas did very well. There were some needs improvement comments related to TCEQ that I'll let them address if you wanted more information. But as a whole, Texas did very well during this assessment. You hear a lot in this commission sealed sources, and I know it's a small part of the total, but on the industrial side, that's where a lot of our sealed sources are, with a few in the medical side. And the way, in addition to having the manufacturer distributors, we also have some service companies, and the service companies are also heavily involved with how we deal with sealed sources. The system is basically set up so that they go out to customers, they get distributed, and then eventually they end up going back to the manufacturer in the vast majority of cases, or they go to a service company. And the service company may be licensed to either do a source exchange on a piece of equipment, or they can take back the piece of equipment and recover the source for potential reuse or disposal if they're unable to find a use. All that transfer occurs as the radioactive material maintaining the status as radioactive material. It's not considered waste at any point in that process. And DSHS does not authorize its licensees to receive sources for disposal. We authorize them for potential reuse. With the system we've had in place, we've been able to consolidate sources in the hands of a few companies that have a high level of expertise and are able to keep the state's inventory of sources safely. Now, with the waste site being available, some of those companies, such as Thermo Fisher, who Marvin Smith spoke previously, are having to consider getting rid of their sources. And the state has the ability to put time limits on our licensees so we can try to expedite that process. But we are trying to deal with it in a business-friendly manner and work within their timetables as much as possible. There's also a huge question that's come before the commission quite a bit about who's the generator. As far as DSHS licensing goes, we have historically allowed the licensee to determine when they declare something as waste and who they declare the generator. So as far as that question goes, we'll basically take a step back and allow TCEQ and the commission weigh in on that topic. Of course, we are happy to give our own suggestions. We do like to encourage that we have disposal options for all the sources, and that our licensees are able to dispose of the sources in a safe manner. Not to say that they're not safe where they are, it's just buried is safer. One of our big parts of what we do revolving the waste site is DSHS is responsible for all transportation of radioactive material in the state of Texas. that means we have approximately 1 million shipments a year. And many of those are routine shipments by radiographers, well loggers, engineering contract companies that are going back and forth to work every day. And each one is an individual shipment. There's a few hundred shipments to the waste site that have this commission's attention and also the attention of a lot of other people. Those shipments tend to be some of the best prepared and most professionally accomplished shipments that we deal with. And we are required under statute to do some additional steps when a shipment goes to the low-level waste site. One of those is we're required to review their emergency plans. And the big part of that is to make sure that DSHS gets notified, because DSHS is the responding agency if there's a transportation accident involving radioactive material. We also have to review their insurance certificates for the carriers or transporters. And we also have to review shipping containers. We need assurance that the shipping containers have been properly approved by the Nuclear Regulatory Commission and Department of Transportation. And if someone is manufacturing them themselves in Texas, then we review their quality assurance, quality control procedures, or if they're doing maintenance in Texas, we also do that. As part of that, we've implemented a registration program where we register anyone who ships, or is a generator, or anyone who transports or otherwise a carrier of waste to the low-level waste site. Currently, we have 50 carriers, or 50 registered users. Now, some of those registered users represent multiple nuclear power plants, so I think we have about half the nuclear power plants registered now. I don't know the exact
Half
number.
in the United States?
Yes.
Okay.
I assume the other half will be coming on board eventually. We are also responsible for transportation on all roads, including private roads. And as part of that, I personally reviewed the transportation at the WCS site between the use areas, and to assure that the transportation methods, markings, the roadways, the transportation equipment that was being used was all at least equivalent to DOT or industry standards for off-public roadway transportation. We are in discussion with WCS that now that they've combined their processing and disposal onto a single license, they're looking at making the roadways part of that license. And so I'm in discussions with WCS about that now. But we can make assurance that we have verified that the transportation that occurs on their site is in accordance with standards. Another big issue, and one that came up at the meeting in Tennessee here recently, was talking about exemptions. So I wanted to address that briefly, since my agency gets involved heavily with exemptions. There are some standard exemptions in rule, and both TCEQ and DSHS have them in our rules. One stems from the NRC Rule 10 CFR 30.70 Schedule A, which is a total activity exemption, and then there's 30.71 Schedule B, which is concentration exemption, and both of those are considered to be NRC exempt. So material that's NRC exempt is not considered to be radioactive material, in which case it can be disposed of at other sites. Now, there's a bit of a catch to it. In 2007, the NRC decided that they must approve all distribution of exempt material. So even though it's below the limit, it still has to be approved by them with an exempt distribution license before it can be distributed. That also, we do not allow sources to be decayed to exempt activity or concentration, and we do not allow material to be diluted to below exempt concentration. So in many cases, you have to have an agency concurrence or an agency opinion on whether or not a material is exempt. And if it wasn't exempt under an NRC distribution license. And so that makes it difficult. Now we can add on top of that, the NRC has a provision for exempting for certain types of waste disposal, which is in 10 CFR 20.2002, and it's frequently called a 2002 exemption. Those exemptions can be used. The Grandview site in Idaho is one example where it's a RCRA Type C landfill where they use, they have an exemption to dispose of radioactive material at a higher level than the NRC exemption, but has been approved as a NRC 2002 type exemption. And
Did Idaho approve that, or did NRC approve it?
NRC and Idaho both
Okay,
approved
both
it.
of them. All right.
The NRC has jurisdiction over the approval process of the radioactive material and has to be involved in that process, as well as the state permitting agency. And that's so it's important that we be clear as to what types of exemptions we're talking about when we discuss an NRC exemption for based on activity or concentration or an exempt device versus a exemption for waste disposal, which is a very different process. As part of my internal review, I found that DSHS licensees are not allowed to transfer waste to an unlicensed site, and a RCRA facility is not a radioactive materially licensed site. So that requires that my agency issue an exemption for such a transfer to occur. And I'm talking with TCEQ about how we're going to go about doing that. And we'll probably come up with some sort of standard or generic exemption that would apply for our licensees that dispose of material in the state of Texas. It becomes much more complicated when you're dealing with other states, because then that state has to grant an exemption, and then the receiving state, Texas, has to grant an exemption, which is already in place. But then you have to look at what each state's process is for granting the exemptions, if they have one. And you also have the compact commission system, where each compact may weigh in. As far as DSHS is concerned, if an exemption has been granted by another state for a material to be considered exempt for disposal at a RCRA site, and it's been granted an exemption by TCEQ for disposal in the state at a RCRA facility, then we do not consider it to be an importation of low-level waste, which would mean they don't have to go through the registration process of a shipment to a Texas low-level waste site if it's going to a RCRA site. Now, that said, the Compact Commission may take a different view. There's certainly room for different legal interpretations as to when something becomes exempt from being considered as low-level radioactive waste. And with that, I'll open up to questions.
Well, my initial question is, what happens if it comes from a state that's not an agreement state?
Then the NRC has to grant a 2002 type exemption for the waste to leave the state to go to an out-of-state RCRA facility under an exemption.
Okay. And I can see all sorts of things, but before I get into that, let me ask you a few other general questions. Tell us a little bit about what does the Radiation Advisory Board do? How is it set up, and what does it do? And I've attended those meetings for years, as you know.
Okay. The advisory board is set up by statute. They are supposed to advise all the radioactive material controls and radiation agencies in the state. So they advised DSHS and TCEQ and the Railroad Commission. And they meet quarterly, and they discuss issues. They have a very active medical committee and an industrial uranium mining committee, and those committees address different topics that they find of interest, and sometimes there are topics that are brought to them from one of the agencies, and sometimes it's a topic that they've read about or something they've been investigating as part of their own work. Each person has a different area of expertise. There are 16 seats, and one of them is public, and each one comes from a different area. Some medical, some industrial, and also so that everyone gets a representative and has a voice on the tribe. And one of their big roles in an advisory capacity is looking at rulemaking. And they advise us when we do a rule if they think that it's appropriate and whether they can concur with the rulemaking, or they can make suggestions, and we will go back and revise the rule based on their suggestions. But it's just one step in a rulemaking process.
And they are set up under the Texas statutory scheme to be the radiation advisory agency to the state of Texas, is what I understand.
Yes, absolutely, yes. And the governor appoints the members.
All right. One of the things you touched on, it was on the top of my head because I read an article that a barge is going to be decommissioned in Galveston that has a radioactive reactor in it, and that's been in the press lately. So who is it that takes charge of that, if anybody, in the state of Texas?
Yeah, I can clarify that. The U.S. Army has a nuclear barge, Sturgis. It was used for producing power in the 70s in Panama until the Panamanians were able to provide onshore power. In 76, I believe, it was returned to the U.S. and defueled because it was no longer needed, and it's been sitting near Baltimore in an estuary decaying since then. Recently, an award was granted to CBI Services, and it is going to be towed to Galveston in late September, early October. Last I spoke to them, they had not selected a peer. They were negotiating that. Part of the reason that Galveston was selected is because in order to reduce costs of disposal at the federal facility at the WCS site, which is where much of the waste will probably end up. And the reactor is basically intact other than being defueled. So there's going to be some highly activated hardware that's part of the reactor components. And it will also have the coolant systems that are lower level activity. There is a possibility that they will, based on cost, look to dispose of some of that material out of state. The Army reactor program is interesting in that it's actually under their own federal jurisdiction. It's not like the Navy program where it's under an NRC master license. So it's actually under U.S. Army license. And they plan to do most of the decommissioning work shipboard so that they don't have to be licensed by the state of Texas. Now, there may be some off-the-ship processing or storage, in which case either DSHS, TCEQ, or both may get involved. It's also possible they could do things like calibrating their own meters and things of that nature where we might have to be involved. So that's something that I'm monitoring. I'm staying in contact with them. One of our big interests, because the NRC is not an agency, they're not going to be responsible for what happens to the rest of the ship that gets released for recycling. And they plan to recycle the scrap metal. So DSHS is going to be the lead agency in making sure that the scrap metal that's released is not radioactive and meets the exempt criteria. It's one of the exceptions to the NRC requiring that they weigh in on all exemptions. Is it doesn't apply to the military, it doesn't apply to DOE. And so in that case, DSHS is the watchdog agency, as it were, to make sure that...
Is that because you just have everything else in Texas?
Yes, yeah, because we have everything else. So we make sure that anything being released in the state is safe enough for Texans to handle.
Let me circle back to transportation for a minute. How does the Department of State Health Services, if at all, get involved with, we've recently receiving materials from Los Alamos that were originally destined for the WIP site when the WIP site was shut down. Is there any special transportation review that you had to do for that, even though it's not low-level waste, but it's radioactive materials transport?
We have not been doing any specific review of the transport. We have been in contact with TCEQ, and in general, any shipment coming into TCEQ, we have asked that the TCEQ on-site inspectors notify us if there's a problem with shipping that we need to be aware of. So we rely on them having hands-on in the field and being able to assess what they're receiving to let us know if there's any problem that we need to follow up on. If there were problems where we needed to assess penalties or fines for something being shipped improperly, then we'd step in.
Okay, let me ask, I'm keep asking these questions because I'm curious about all this stuff. General licensee can possess radioactive material under a general license, is that correct?
That's correct.
Do they have to, what kind of information do they have to share with you when they're possessing that radioactive material?
Well, there are two different classes of general licensees. Some general licensees do not have to share any information with us other than notify us when the material's been disposed of. They have 30 days. We are notified by the manufacturer when the material's distributed so that we know where it is and when it got there. And we maintain a record from all the manufacturers as to where that material's been sent. We also have a provisioning rule, what we call a general license acknowledgement, and it's simply a registration where someone says that they have the device, and we put on a registration form piece of paper saying that we acknowledge it's there, or here's the list of devices we acknowledge you have. And then we have each of those people do an annual self-assessment where they essentially inspect themselves to make sure they're doing proper leak tests and shutter tests and inventorying and maintaining the devices properly. So that's the system we have in place. And with the general license, a lot of people don't understand the general license is in rule. It's actually written into the regulation. It's not a separate piece of paper.
You say that you're notified when manufacturers, including out-of-state manufacturers, ship devices into Texas?
That's correct. Any in the U.S.
Okay. And all right, I'll stop there. I don't want to ask questions, but let me ask you. Texas is an agreement state, and NRC has an agreement with the state of Texas. Who signs the agreement for the state of Texas? Is it the state
governor.
of Texas? The governor's office does?
Yes, that's an agreement with the governor.
How does the various agencies like the Railroad Commission and DHS and TCEQ participate in that agreement process?
Well, the Railroad Commission, as it turns out, is not involved because the NRC does not have jurisdiction over naturally occurring radioactive materials. So, and since the Railroad Commission only has jurisdiction over oil and gas naturally occurring radioactive material, then the NRC has no interest. Now, the TCEQ and us both are responsible to, under the governor's office, to for our end of handling that agreement and complying with it.
Norm, NRC, as I recall, regulates source, byproduct, and special nuclear material. Is that correct?
Yes.
Aren't there a bunch of other kinds of radioactive material out there that NRC does not have anything to do with?
Yes. Yeah. Well, and it used to be they didn't regulate accelerator-produced material, but they picked that up recently. They also picked up some discrete sources of radium, which include things like radium dial wristwatches that they didn't used to regulate. But there's a lot of naturally occurring radioactive material. Much of it we see is radium, uranium, radioactive lead, and polonium coming from water and water systems, and also from oil and gas. And we see a lot of that. It's actually because it's natural and it's everywhere, and a lot of people aren't aware of how much they may have because they don't have meters. So it's an area of concern because we don't always know well what the risks are, and sometimes a licensee, like say a petrochemical plant, may not have a good handle on what their risks are with naturally occurring radioactive material.
Okay. I've been asking questions. Are there questions from other commissioners? Go ahead, Peter.
You mentioned a while ago that the naval programs were under a general license from the NRC.
No, they have a master license from the NRC.
Say a little more about that. I wasn't familiar with it.
Okay, the Navy has what's called, and the Air Force also has one as well, a master license, which basically it's like a broad scope license where they're allowed to designate their own users, their own uses, their own use areas, and they have all their own oversight. And then their program is periodically reviewed by the Nuclear Regulatory Commission to make sure they're complying. It's set up that way so that
Complying with what?
with the NRC regulations, primarily with dose limits to the public and to the workers.
And those are set how?
Well, those are in 10 CFR Part 20 in the rules. And there are also reactor regulations where the NRC, where the Navy, for example, has to be at least equivalent to the NRC with regards to reactor safety. In most cases, in my experience, having worked for the Navy, that the safety level is increased in the Navy versus in the commercial reactors.
And when did that regime come into being?
That goes back to early days. I think you'd have to go with Hyman Rickover's Navy. It was set up that way.
Well, there was no NRC.
Well, okay, I misspoke. But it was early on in the process. I can't give you the exact history. I'm not well versed in it.
And why is the Army different?
I asked that question and I didn't get an answer. I would have thought that the Army would have had some NRC oversight when they were making a nuclear reactor, but consequently, that's why DSHS is going to have to take more of an advanced role in this decommissioning.
John?
Back to the barge that will be going to Galveston at some point. I thought the state of Texas, and particularly DSHS, claimed jurisdiction for what are considered state waters.
Yes, Texas does have jurisdiction in the state waters, but not aboard the ship. The ship itself is like a Navy vessel that has a nuclear reactor on it. The reactor itself is under Navy jurisdiction because it's shipboard.
So you're saying that in this case the reactor is under the Army's jurisdiction?
Yes.
What if they pick that barge up and put it on shore?
Once they put any of that equipment on shore, it would be under state of Texas jurisdiction, and depending on whether it was waste processing or some other activity, it would be under TCEQ or DSHS jurisdiction.
I guess my question or concern is DSHS does regulate radioactive materials being used at sea in state waters. That just because they're on a ship, that's still regulated. So why does a ship being I can't make the two fit together.
Well, the other areas where we regulate, such as well logging or radiography on oil well systems or piping, in that case, it's actually external to a vessel, so that is considered to be under state of Texas jurisdiction.
Well, I know both Texas A&M and University of Texas at Austin use radioactive materials at sea in state waters, and that is regulated by dishes. Those materials are being used on a ship.
Yes.
So what's the difference between the ship being at the pier and it's an Army ship and you're not regulating it versus Texas A&M or UT has a ship at the pier with radioactive materials on it and you are regulating it?
Well, that's a ship that's licensed under and registered under the state of Texas.
That ship could be flagged anywhere. It's irregardless of where the ship is flagged. I guess I just, it seems unusual that you could have a ship in the state of Texas in waters that you're saying you don't regulate, and yet in other circumstances you do. But
yeah,
perhaps there's a nuance that I don't understand.
Yeah, only because it's U.S. Congress authorized it.
Thank you.
Okay,
Ms. Morris?
Going back to the 2002 rule, the NRC, the exemption they can
Yes.
get. Does the state of Texas have have that process, or can we do that?
Texas does, and this is a part of TCEQ rules, so they can correct
Okay,
me if
TCEQ
I'm wrong.
rule,
But my understanding is that TCEQ does not have the same section of the 2002 rule, but TCEQ does have an exemption authority given generally, and so they can do a 2002 equivalent exemption under their general exemption authority. And some states do it that way.
If I could ask one additional question.
Sure.
When those exempted materials are shipped in transit, what kind of paperwork goes with those shipments?
All shipments have to comply with U.S. Department of Transportation regulations. So, except if it's an NRC exempted material, which means it meets the criteria in the 10 CFR 30.70 or 71 or another NRC granted exemption. In that case, it's not considered radioactive material, and then it only has to be shipped in accordance with whatever hazards may be present. If it's low-level waste under a 2002 exemption, then it still has to be shipped in compliance with DOT regulations.
Would those
material.
materials being shipped under the 2002 exemption, would they be accompanied by waste manifests?
No. No, not if it's going to a record facility. It wouldn't have to be, it would have to be manifested as a record type waste, not as a radioactive waste.
So the NRC form
540.
540 and 541 would not accompany those shipments.
No, I don't think so.
Okay.
Not required under our rules.
Thank you.
So if a generator in Ohio was using a broker in Tennessee, who would determine the exemption, the 2002 exemption? Would the generator in Ohio get an exemption, or Illinois get an exemption for their waste to be considered okay to go to a rec facility?
My understanding.
And then the broker would ship it to the record facility, and it was not at the record facility that the determination is made?
Yeah, my understanding from reading the NRC guidance, and there's a guidance document, I brought a copy, and I sent it one to Lee Ing, FSME-12-025, which goes through basically those scenarios. And my understanding, it's the state where the waste is generated that has to grant an exemption, in addition to the receiving state.
Any other questions from any of the other commissioners?
Are y'all gonna put up monitoring devices by this vessel?
We plan to do routine inspections at the vessel.
Not on the land.
Oh, on the land?
Ship, so
Well, we haven't discussed that yet, but that's a good idea.
it is a good idea. Take the liberty of speaking for the
All right. Thank you, Judge.
Peter?
So I've been doing a little checking since to try and clarify my own perplexity. Let me see if we have a common understanding over this master materials license and the Navy. Because I'd always been told, for example, that a lot of the larger military facilities, when they had problems, Rocky Flats, Hanford, Kerr-McGee, were unregulated by the NRC. This master license, I gather, now applies to medical and industrial uses, but not to weapons.
No, it does not apply to weapons.
Not to shipping, not to nuclear Navy type facilities, submarines.
Okay.
That seemed right to you too?
Yes.
Now I understand.
Although that said, that generally the radiation safety officer at a facility that has nuclear, either nuclear reactors or material, has to deal with both. And so a lot of that is done in parallel through the same safety office working at the Navy.
I'm good.
Thank you. Any other questions or comments?
Yeah.
Go ahead, Jay.
So DSHS deals with transportation in the state of Texas.
Yes.
How is it, does every state have its own way of dealing, their own regulations in terms of dealing with radioactive waste transportation? Or what's the affiliation? What's the communication?
Well, the Waste Transportation Authority for radioactive material transport is, if it's an agreement state and there's agreement with that state governor, that governor can decide where he wants to put that authority. So there are some states where their state Department of Transportation has authority over radioactive material shipments. In other cases, it's with the Radiation Control Agency, and such as it is in Texas. And that's up to each individual state and their governor's office to decide.
So there's no consistency or protection of the public from the standpoint of transporting. I mean, we're going to be transporting from Vermont to Texas.
Yes.
That's quite a ways and through a lot of states. I guess I'm perplexed as to why there's no specific. I thought it was the DOT that dealt with a number of regulations anyway that states have to comply with, but in terms of enforcement and safety and public notice, it's different in each state.
Well, for interstate transport, the U.S. Department of Transportation is the lead agency, and they do most of the actual oversight for those types of shipments.
Mm-hmm.
Now, there are some individual states that have their own rules that are sometimes stricter. They can't be less strict than DOT.
Okay.
But the U.S. DOT is the lead agency. There's no mistaking that. Even in shipments within the state of Texas, they still are the lead agency.
Okay, and you have strict rules about public notice of through the area. I mean, if there's a lot of nuclear waste being shipped, high level anyway, through backcountry roads, are people notified?
Generally, no. And the U.S. Department of Transportation has rules regarding how routes are selected. There's a general rule that they are supposed to take the quickest, safest route in general. And they are also to avail themselves of loops around city centers. I have discussed with the transporters of shipments going to the low-level waste site, and all of them have said that they go ahead and follow the Texas DOT-approved hazardous material shipping routes. Even though technically those routes do not apply to radioactive material, they do it anyway because those have been designated for hazardous materials. There are certain materials considered highway route controlled quantities, and in those cases they have to be shipped on interstates and they have to go to the nearest exit or entrance to the interstate from wherever they pick up and drop off the material. For the most part, shipments going to the Little waste site in Andrews are not highway route control quantities. Now, all shipments going to the WIP site to go through Texas are treated as highway route control quantities, even if they're not. And so they all go on I-20 if they're going through Texas. I also should have mentioned that we're required by statute to provide training to first responders along routes to the WIP site and also to the low-level waste site. So whenever we register a new transporter or shipper, we find out what routes they're taking. We identify the counties that are and cities that are involved, and we provide training to those jurisdictions.
And those jurisdictions know when it's coming through?
No.
No. Okay.
No, in general, there isn't any notice. And as far as the types of materials that are considered route control quantity, that's considered need to know. The notice goes in to Richard Ratliff. He's been designated by the governor's office as the point of contact. It is forwarded to 2 other individuals. I'm one. And then one of those individuals notifies the Department of DPS, the Department of Public Safety, so that they're aware. And those are the only people that are notified.
And that's for security reasons?
Yes.
Okay. Thank you.
Other questions? Ray, thank you very much.
I will say, Jan, I'm just sitting there thinking, there's probably I could say 100 and miss it by 100 in Andrews County right now that has radioactive material in it, driving up down County Road, State Highway. I thought really appropriate.
Yeah, and that's because the oil field and industrial radiography business. Yeah, I understand.
Yeah, as I said, there's more than 1 million shipments in the state every year, and no one has the ability to track all of them.
I was thinking about the couple of hundred that you mentioned.
Yes. Well.
All right.
All right. Thank you.
Thank you, Mr. Trump. We appreciate the education. We really do. Thank you. All right. Rod, you're up. You may have more to talk about now.
I am appreciative that DSHS was right after the break. I hope you guys are ready for another one shortly. Look at the time. Rod Belter, WCS. I would like to report that we have hired a new individual, Betsy Madru, here in the front row. She is the WCS Vice President of Government Affairs. I think we're both very pleased. We got the office lease done yesterday, so she should be officing in the Westgate building, not far from the Capitol here, and be available as questions arise outside these meetings and things like that, and is happy to interact. And we're happy to have somebody here in Austin. It's been we have not had a WCS employee here in Austin before, so this is kind of a growth opportunity for us. But obviously, there's lots of interactions between this commission and the other regulatory agencies and governmental and legislative bodies. WCS operationally, we disposed of about 5,000 feet, 6,580 curies for the year to date for the fiscal year, running from September 1st to April 30th. In compact, that was about 4,200 feet and 1,000 curies. Decayed out of those 6,580 that we've taken for everyone, that's decayed down to about 63, 65, so roughly 200 curies have decayed off during that time frame already. License updates, we did have a major amendment that was sent through technical notice on April the 20th, so that is out for comment. That amendment included updates to the performance assessment, expansion of the landfill capacity, and reduction of financial assurance, among other things, in that amendment. I think we've talked about most of those at previous meetings, but hopefully that amendment will be complete sometime this fall. And that is all the comments I had prepared.
Any commission questions for Mr. Balser? I did notice, because I read things, that Val High reports that WCS is planning to have a great fiscal year in 2014. Now, I think I saw something like that.
They tell me the same thing.
All right. And have you gotten all the shipments that you're going to have? This is not low-level waste, but we're curious about it because it comes into Texas from Los Alamos, or were those interrupted? I read some press about that.
Yeah, so as you may be aware, we did start receiving shipments from Los Alamos that were destined to the WIP site for disposal. This is transuranic waste. They were trying to meet the New Mexico governor's goal and get that off-site by the end of June. As we started receiving those, they did identify some drums at the WIP site, and they caused a pause in operations. So all shipments have stopped at this point as they continue to do evaluation and analysis. All of the material we've received have been overpacks. So there's drums, and they are overpacked in a standard waste box. And that waste box provides additional containment and closure. Those are all stored inside our container storage building on site, which is licensed for this kind of material, and we've got strict monitoring controls and radiation safety reviews and daily monitoring of the materials.
I also read, maybe I misread, a statement that there were some waste acceptance criteria issues, or were there, associated with that material?
So there are not a lot of certainties at this point. There are a lot of hypotheses and theories, and so at the WIP site they have identified a certain waste stream that they're not certain was treated the way it should have been treated, and so they are evaluating that and what kind of impacts that could have had, and could that be a source for some of the contamination that they found at the WIP site.
Well, I'm sure everybody in the country is glad that you guys are there and available to do this in cooperation with the Texas regulatory agencies and everybody else, because it's something that needed to be done.
It's been a very interesting project. So.
All right.
How much material is involved?
There were going to be about 150 shipments, and we've probably taken 40% of that at this point.
Do you all have any knowledge of the original source, where it came from?
They're still trying to identify, as far as at the WIP site, where that contamination came from, that original source. They're still trying to identify exactly what that was.
What differences, if any, does having that material on site make in the way you have to operate?
It really hasn't had much. Obviously we have more containers in storage, so it takes longer to go through and do your daily inspections and things. But other than that, it really hasn't had a change. We were already licensed. We didn't need any amendments or anything to take the waste. In fact, we had an agreement with the WIP site back in 2004 as a safe haven standby facility. That agreement had expired, and then when this incident happened, people who were still familiar with that contacted us right away and put the balls in motion basically to reestablish that type of contract.
And am I right in understanding it goes back to WIP when they're in a position to take it?
Yeah, so it arrives directly from Los Alamos to our facility via the TruPaks, via the established WIP routes, one of which goes right by our facility. We don't unpack it. We don't do anything to it. We keep it as is. They are there monitoring us and watching our movements of that material into storage. We'll repackage that, and they'll move it from our facility 60 miles away to the Carlsbad WIP site.
Sure. John?
Do those materials tend to be pretty low dose rate, Ron?
Yeah, all of this is contact handle waste, and particularly being overpacked and things, the dose rates we're getting are much less than we anticipated.
Thank you.
Any other questions? All right. Jane?
Rod, first, I want to thank you and your team out at WCS. I went to see the site yesterday, and they were all three people that were there, the hydrogeologist that answered a ton of questions and is giving me a lot of printed material, the vice president. All of them were absolutely wonderful. And anybody who hasn't seen it since it's been up and running, I would urge you to go check it out. I have a question about the compact facility. Do you know how much is in compact waste now there? as opposed to out of compact waste?
We do. I do not have that number off the top of my head, but we do know or lifetime to date how much volume is in that facility versus Curie's.
Yeah.
Sherry's probably going to look it up and let us know.
I only have it for this year, but I can get it.
That's fine for
Yeah.
this year. Well, isn't it cumulative?
Yes, but
Yeah.
I just have the numbers for the fiscal year right here. I can get you the totals.
Yeah, we'll email you the totals for life to date.
Okay, thank you.
Let me clarify. Sherry will email you the totals life to date.
I understand. And Rod, thank you again for your patience in answering all our questions about things that really are a little bit beyond what compact facility, but we're curious, of course, about your total operation out there and the impact on people in Texas. And thank you for allowing us indulging us with
We're
responding.
proud of the facility, happy to answer any questions. We don't want this to be something that looks like it's, we're trying to hide the ball in anything. We're very open and transparent in what we do.
All right. Thank you very much. Appreciate it. Okay. We can keep going on the agenda. We don't have to. I think we'll be able to finish shortly. Next is the chairman's report, and I'll try to be short, but those of you who know me know that I never am, even in spite of the fact that I say that all the time. The first thing I wanted to point out, and a lot of these comments will be able to be for the commission, we had completed our private audit, and we have an audit report done on the first year that offer covered, which I think was fiscal 2012. Was that correct? Okay, so that's been done, and the report's available, and I think we'll be posting it. Will we, Lee?
We're posting it as part of the, at least currently, we can change our mind, but right now we're posting it as part of the 2012 Compact Annual Report.
Yeah, and that gets to another topic, but we're also undergoing a comptroller's audit for that same fiscal year, Texas State Comptroller's Office. That has not quite been done yet, and they have different points of view. The comptroller's audit is dealing with Texas appropriated funds, and the audit that we have to do is under the compact that looks at all of our funds, whether they were coming from Texas or not, because we have some funds that remain from contributions from Vermont, and so we cover those in that audit. So explaining all that to the Texas comptroller has been an interesting proposition. The reports, one of the requirements on us is that we file an annual report, which we've drafted several, but I don't know that we've ever fully submitted one, but we're about to, because we have a fiscal year audit now complete, and the audit is supposed to be attached to the annual report. So we're about to do our first one, and I'm sure we'll have a draft available, and it may be that we just submit it because it's a requirement from the commission to do that, and Lee has drafted something that I've drafted, and we may just attach a copy of the annual report. Of course, if we do that, we'll post the whole thing on the internet so everybody can see it. It's a requirement under the compact that it go to certain public officials, both in Texas and Vermont, and we're about, as part of that, we're about to enter into a contract if we can find, we're going to issue a request for a proposal for auditing firms to do a subsequent year audit for fiscal year 2013, so we can put that audit together and then submit it with the next annual report, and then we hope to catch up next year, because at the end of this fiscal year, which ends August 31st, we'll start the process to do then an audit for this fiscal year, and we will then be able to get on schedule to do these on a more regular basis. It's been a difficult process, and the judge and I are the only two ones, other than our attorneys, of course, who've been around since this first started, and we could talk about the history of how we started when we were named, and I'll just say this: there were no funds to support anything we did, so we had to figure out how to do it without any money, and that has led to some interesting problems and discussions along the way, and we've done what we could. We're gradually catching up now that the state and the site's in operation, and Betsy, when she was with Senator Schelger's office, the last session, they did a lot to help us out on our funding operation. We're hoping to smooth that out so we could end some of these problems. as part of, so we're about to generate reports, and as we get them generated and everything is included, we'll start filing them and post them on our website. We are still looking for a person, as we said we would, to help us with various fiscal matters, because they're not just fiscal matters in terms of audits and that sort of thing, but they're fiscal matters in dealing with the system in the state of Texas for accessing appropriated funds. And the difficulty that we have is under the Texas Constitution, funds coming out of the state treasury have to be covered by an Appropriation Act. Well, when the Appropriation Act covers it, they just don't give us a pot of money. And what they do is they say all of these requirements that are normally associated with state appropriations attached to this money, so we have to learn what all these rules are. And learning what all those rules are and then trying to figure out how, as a federal entity, because we're set up under federal law, how we fit into this system has been a vexing problem. And we're doing our best to address that. And I'm just telling the commissioners, because we spend a lot of time working through these issues locally when we can, and Lee really, and Audrey, they take the burden on this, and Karen and Jim as our lawyers, they really help us out a lot. And but there's still some lingering issues that we have to work through, and we're trying to figure out the best way to deal with them, and we'll keep the commission informed. So we're looking for somebody really to help us do this with the interface with the state of Texas, really, the Legislative Budget Board and the Comptroller's Office, so we could smooth out some of these problems. And we've got some ideas, but we haven't sent out a request for proposal yet for that person. We also, last meeting, talked about a risk assessment, and I think we have signed an agreement with somebody. We have not yet signed the agreement with somebody to do that. Okay. We're still working on that, because that's one of those things that we're required to do also under Texas law because of the appropriation. They have certain requirements that they translate to state agencies, and they say, you are one, and we say, no, we're not. And they say, do it anyway. And so we make a decision about whether or not we want to fight about it, and if it's faster to do it, we just do it. And we're looking for an auditor for this year to do the next audit we have. We have other things that we have to go through, like document management things for requirements under state law that technically are not in the compact, but because of the appropriation, they can be triggered. So we end up, as I said, dealing with questions of, is it a good idea? And most of the time it's a good idea, so we just go ahead and do it. But it takes time, money, and effort. So those are some of the things we're going on. As part of the next legislative session that begins next January, the Legislative Budget Board has become active in Texas, and Lee has been talking to them about the requirements for the Legislative Budget Board to get through the appropriations process in the legislature. And then that's just part of what we have to do. And one of the things that I'm going to say now, and it's been pointed out to me, but it's absolutely true, the great thing about this group of commissioners, the great thing about it is that they all work. We have 2 contract people that are helping us. We don't have big staffs. So the commissioners here are the commissioners who do the work of what's going on and going forward. And we all pay attention, and everybody chips in. And I'm very grateful to each of you for each of your contributions. In that regard, I'm going to next switch to something that we've been talking about, and it's sort of grew out of the rules, but it sort of grew out of reports from WCS and from TCQ about this whole issue of importation of waste into the compact for disposal other than the compact facility. At the RCRA facilities, or any RCRA facility, actually, I guess it would work that way. If the rules are in place, and particularly if it don't need a radioactive materials license, it could come in And if it's not radioactive waste, we don't need to worry about it. But if it is radioactive waste, we probably need to pay some attention to it. So one of the things I have decided to do is to explore the context of some of what you heard today from all of the people, and have you heard in the past about dealing with this importation of this waste that comes in and is evaluated or exempted or whatever it happens to it and ends up going to a RCRA facility. We need to understand the context and particularly the legal ramifications, the legal background, all of the issues and regulatory requirements around that for our satisfaction. And so I'm going to appoint a committee to take that job on for the Compact Commission. I've talked to several members of the commission, and they've all, so far, until today anyway, they said that they would be glad to take it on and help us out to gather information from Department of State Health Services, from TCEQ, from WCS, from brokers, generators, anybody else who and just so we know if there is a role for us and what it's supposed to be, and we can come up with some conclusions about that as a commission. I'm going to appoint Brandon Hurley as chairman. He said he'd be glad to do it. There are a lot of legal issues involved. Brandon's a lawyer, so obviously he has all sorts of time because he's not heretofore active in doing that much for us. He's new, and so he's got 5.5 more years to go on his term, and so I decided to name his as chairman of the committee. Other who've agreed to serve on the committee to help us gather information are Judge Dolgener, because it may be an issue important to Andrews County, and he certainly needs to be kept informed. John Salzman has looked at these issues from the technical side, and we need some technical help on this to understand the processes, because we certainly don't understand them. And that's 3 members. And then, naturally, as all of you know, I've always wanted to include a representative from Vermont. And yesterday I talked to Mr. Saudick, who's not here, and he has agreed to serve also. That's 4 people. And so the 4 members of this committee who are going to be designed to interface with anybody who wants to talk to us about this and then come back to us with a report of the contextual background, if you will, and the regulatory background for this issue to see if it impacts us, and if so, how. Mr. Hurley will be chairman, Judge Dolgener, John Salzman, and Dick Saudick. And I'm going to leave it entirely up to Mr. Hurley to Brandon. You're going to schedule everything and be in contact with the committee members. And, of course, Lee Ng will also be involved to keep us all going and on track. At this point, I don't know whether it will spill out into the rulemaking committee as a separate matter or as an integrated matter. That's something that we've talked about in the rules committee, but we just don't know yet. But that's where we are. And so I just wanted to make that announcement to everybody. So if you have questions or want to talk to us about it, talk to Brandon. Basically is what I'm saying. Travel, we have some travel coming up. Lee has been asked to speak at the Southeast Compact meeting coming up in June, I guess. And you have another meeting that you're going to somewhere. The Low-Level Waste Forum, for those on the commission, the next Low-Level Waste Forum meeting will be in Denver, Colorado, October 30th and 31st. Ma'am? Halloween in Denver, Colorado, which ought to be really interesting given the Colorado laws now in place. And I'm looking forward to that if I go. And so it'll be a cultural experience. I'll put it that way. So I just wanted to talk about those travel things. I know that the waste management meeting is coming up, though it's one that's typically held in September in Las Vegas. That's coming up, and I just got the information about that yesterday. I don't know if we're invited or not, or whether we'll go or not. So, but these are different travel things that are coming up. I've already thanked the commissioners for their work. I could not possibly be in this position. I would have quit a long time ago if it weren't for all these people supporting me. So thank you very much. Next on my agenda is meetings, and I wanted to specifically talk about this. Our next meeting is in July the 10th. and that will be in Austin. We had discussed, and then yesterday and today I talked to the Vermont commissioners. We have another meeting scheduled for August 14th. It now appears that we are going to do that one in Vermont rather than in Texas, in August 14th. We haven't set meeting dates beyond then, but we'll resume another schedule, and Lee will talk to us about this when she gives her report in a little bit, in just a few minutes, I hope. And that was really the last thing on my agenda. So unless somebody has any questions of me that you want to ask in the commission meeting, I'll be quiet and let Lee talk. Peter?
Just with regard to the August 14 meeting in Vermont, we've been talking a little, of course, you talked about the size of Vermont. You really don't want to be doing that in Texas, but there are different, there are different parts of Vermont, and we were thinking of suggesting we do this one down south, closer to where I live. There's some pretty nice facilities, and the lead time's a little shorter than would be ideal, but we'll look into it right away.
Thank you.
If that's acceptable.
Sure, it's acceptable. We have to post notice, but that's done generally 10 days in advance of the meeting, and we don't know what your requirements are for notice. But once we have a location, so we can spread the word, we'll do that and let everybody know so they can begin to think about travel arrangements, whatnot. And please, Lee is glad to help work, because we tend to, we record all of our meetings. We don't keep minutes. And so we record them, so we have to make arrangements to do that. And generally, we have at least telephonic connection with people in Texas who, for whatever reason, don't travel, but they want to listen and perhaps participate. So those are the practical issues that we have to work out. So, and we'll be glad to help you work on this, and so you can understand what we do.
We'll be in touch and be sure that the capabilities there are equivalent to what we've had in Montpelier.
And you'd have to fly into Albany as opposed to Burlington. I mean, you wouldn't have to, but instead of driving 2.5 hours, you could drive an hour. So
Well, is Manchester available also?
Manchester, New Hampshire.
Yeah.
Yeah.
Because that's 2.5 hours from Montpelier, I know, because I've done that trip.
Yeah, the other airport that's a little closer is Hartford.
Okay.
Connecticut, yeah.
All right.
So as long as you can get approval to fly into another place as opposed to.
I generally fly into Manchester when I come to the meetings in Montpelier, and so that's my choice anyway. So we haven't had any problems doing that. So Southwest flies to Manchester, so it makes it easy. Okay.
So what city would it be in? Probably Manchester, Vermont.
Okay, in Manchester.
We think.
Yeah. All right.
Judge, I'm not sure you can get to Manchester, Vermont from Andrews, though.
Gotta
go a day early, that's why me and the comptroller had a little visit, but they can't. They won't know why I was flying the day before. I think I left the day of.
Yeah, it's one of those issues I've learned that the Texas comptroller is not really that familiar with the geography of Vermont. For some strange reason, I can't figure that out. But anyway,
They believe it's a county in Texas.
I have no idea. So, at any rate, go ahead.
Chairman, can we get copies of the audit, the one that we've done, and or at least electronically?
Yes.
And the one when the comptroller comes out?
Yeah, as a matter of fact, the audit that was done was distributed to us electronically, so we'll be glad to, and it was, yeah, we can do that even in advance of the time that we put it.
Yes.
So, we don't have the comptroller, it hadn't been concluded yet, even though it's been going on since September, August. Yes. Okay. Lee, you're up.
I don't have much. I know my place on the agenda. Everybody's waiting on me, so mine's always real efficient. The one thing I wanted to mention as part of my report is, as the chairman mentioned, the Texas legislature goes into session this January. And although that seems a ways off, it really isn't. And one of the things that will be important for us as a compact commission to do is to put together a legislative appropriation request. It's the way that we communicate with the state of Texas and the Legislative Appropriations Committee what we think the appropriation is we need and begin the process of trying to secure it. I will be putting that together as a draft. It will look extremely similar to the one that we did 2 years ago, unless I'm directed otherwise. And it will be on the July agenda. And so if any of you have questions or input or would like something different to be considered, please let me know so I can, because I will be beginning that process soon for the legislative appropriation. Another thing that goes with putting a legislative appropriation request together and then advancing it in the state of Texas legislature is, as the chairman said, a heightened education process. Because our name starts with the word Texas, it's very easy for folks who work for legislative committees to assume we are a state agency. And so being able to educate folks that we are, in fact, not a state agency and that we derive from a federal compact and that we are very fortunate that we are actually combined with the state of Vermont in how we conduct our business takes a while. The mere fact that we have a commission to staff ratio of 6-to-1 is mind-numbing to people. It's usually quite the other way around. And so that's another thing that we'll be working to do as part of this process, and primarily through the legislative appropriation request process, is allowing new staff members to understand who we are and to understand that our appropriation requests may be, and our processing may be different because it's important that we consider the needs of Vermont as we move forward, as opposed to a simple state of Texas agency. Our first hearing is next week, May 21st. I'll be attending that hearing. It's an interim hearing, informational only. It's not expected to be a very big deal, but in the interim, that process begins Wednesday. So, the other thing I'll say about in my report is I heard loud and clear that there's some people who are interested in seeing the processing and manufacturing facilities in Tennessee. I'll be reaching out to make that happen. That would be a very easy meeting to make happen. And I would be happy to encourage anybody that would like to go to please attend. I also heard a very heartfelt encouragement to visit the site compact facility from Commissioner Sanders. So if any of you would like to have something like that happen, please let me know. We can easily work with WCS and would be happy to make that happen for those of you who have not yet seen it or would like to see it again. And then another thing I'll mention, we have posted on our website, on our reports page, we now have a table of the volume and curies that are disposed of at the compact facility, both in compact and out of compact. Those numbers are cumulative. They are updated quarterly as requested by the commission. And so if at any point you would like to see the information there, I invite you to do so. Again, it's quarterly, so we'll have our next update at the end of May. Actually, the beginning of June when the May quarter ends. And so that's another avenue of information that we've made available that's clearly available to you. That concludes my report. I'm here to answer any questions you have.
Do you want to talk about meetings beyond August yet, or do you want to wait till July?
You know I always love to talk about meetings in advance so that we can, it's an ongoing debate, so that we can plan. But I serve at the leisure of my commissioners and my chairman, so it's pleasure, leisure, I can't ever remember, congeniality, but so whatever y'all would like to do, I'm happy to serve.
Well, I'll just observe, we have the next two scheduled, one in July 10th, one August 14th, and it's not too early to start talking. We know that and when we have them in Texas, it's really a question of making sure our Vermont commissioners can, and we need to do it far enough in advance so they know what to expect also. So, and so about how long after the August meeting do you think? Late September, early October, something like that? What are you thinking? August 14th, it's going to be the middle of the month, so I'm thinking later in the month of September might be, that's about a 6-week interval after that. Is that sufficient, or?
September 25th,
25th works for me, but I don't know what anybody else thinks.
No, do we know when Dick has to be in Texas anyway?
No.
Has to be in Texas.
I don't.
October.
October.
Early, late? Do we
Late, I
know?
believe.
Late. Well, that gives us plenty of time. We can have one then too. Or, you know, a little bit after that, depending upon what his schedule is. Do you want to just wait to talk to Dick?
No, it's not, we can't wait all the way until then,
Yeah.
so maybe.
No, I'm talking about to know what his dates are.
Right, we do have to have another one before October.
Before the end of October.
That's up to us. It's up to you guys. You're the ones who travel down.
Just as a guess, I suspect we will perhaps get several applications, perhaps it would be on this agenda, so that those people would be basically approved and ready to ship September 1st. Would you guess that, Ron?
I hope you get lots of applications at every agenda, so.
Yeah.
I'm just thinking that the new operational year will start September
Yeah.
1st.
I think you're right, a lot of agreements may end and then want to renew.
But those we would deal with at the August.
Correct.
Another thing I'll mention, Commissioner Sowdeck is also on the Rules Committee meeting.
Yes.
And there has been discussion that we would, given the regular nature of those meetings, that there will be meetings associated with that committee as well.
So can we wait? I mean, it's 6 weeks to September 25th. Can
No.
we wait 10? Probably not.
I think it would be beneficial to, if we're going to schedule, let's just tentatively pick the date of September the 25th now. And then everybody will then know after the August meeting when the next one will be, and let everybody plan for that. And we'll shoot for our September 25th in Austin, unless I hear from some objection from somebody. Okay, that gets us out.
July the 10th is in Austin.
July 10th is in Austin, August 14th, someplace in Vermont, southern Vermont. And then September the 25th, we'll be back here in Austin. And then at that time, we ought to have we won't yet because the early filing deadline doesn't start until after the general election in November. But we'll begin to hear rumblings more about legislation, and we ought to have a better report upon anything that we see coming up. And so maybe by that time we'll be able to give a little report about that, as well as do all of our other business we typically take care of. Okay? I think that's the last item on the agenda, so I'm ready for a motion to adjourn.
So moved.
And we are adjourned. Thank you very much, all of you who came and participated, and we really appreciate it.
Take care of yourself.